What is attorney-client privilege? So the attorney-client privilege is a privilege that is found in the Texas Rules of Evidence. It is essentially the embodiment of what's special about the attorney-client relationship. The significance of that relationship doesn't really need to be stated, right? We all understand that there's times in our lives where sometimes you need to consult with an attorney, and obviously those communications are highly sensitive. And really, if we are to fulfill the end goals of the justice system and the legal system, which is to ensure that everybody's rights are fulfilled, this rule is really the foundation of that system. What is the attorney-client privilege? Well, essentially, anytime somebody is making a communication in an effort to secure services from an attorney or to get counsel on an ongoing legal matter, those communications are privileged, okay, or confidential. When you are talking to an attorney's office, whether that be trying to secure representation through a staff members are also embodied within that attorney-client privilege. They are considered agents. A couple caveats with that, obviously, even if you don't retain an attorney for that particular issue you're calling them about, that's okay. The privilege still protects communications made to attorneys or their agents, even if they're ultimately not hired, if you never hire them. Another thing to know, however, is that the substance of what you're talking about, let's say it's a criminal offense that you're charged with or you're under investigation for, it's not inherently confidential just because that's the nature of the conversation, right? It also depends on who's with you, if there's anyone else with you when you're talking to an attorney or attorney staff, attorney's agents. So in other words, they have to be confidential communications. They can't be communications made in front of family members, in front of friends, okay? If that happens, there's a substantial chance that those communications would not be considered confidential because they're not being spoke strictly between an attorney or their agents. Another exception to the attorney-client privilege is the fact that some people might say, I'm going to go do this. I'm going to go commit this crime. Interestingly, a defense attorney is not required to disclose that information to law enforcement unless that crime might result in death or substantial bodily injury. Exactly where that threshold meets is a case-by-case situation, but they're not required to disclose. However, they may disclose in situations where even death or substantial bodily injury isn't going to result. Ultimately, the privilege belongs to the client. And so it's up to the client to decide, in most instances, whether to waive that privilege or not. So there are times where a client could say, no, attorney, you cannot disclose this information to anybody. I'm essentially effectuating my rights under attorney-client privilege, okay? Now also, that privilege stays with the client indefinitely, even beyond death. So just because a potential client or new client or any client communicates this information to you, just because they die later does not mean that that communication is no longer privileged. I hope this has been helpful. I hope this has been informative. If you have any questions or comments, please leave them down below. Otherwise, you can check us out at versustexas.com.